Ms. McDougal, I have a few questions for you. Backpage argued in the courts for the better part of last year that the Permanent Subcommittee on Investigations was seeking, and I quote, constitutionally protected documents, end quote, through a subpoena that, quote, strikes at the heart of Backpage's editorial decision-making, end quote. I'd like to direct you to a couple of documents about that so-called editorial decision-making. The first is the spreadsheet at Appendix 000158. Andrew Padilla in this document described as the, quote, most current list of coded words to be stripped out of adult ads, including Lolita, teenage, rape, young. The second document is the spreadsheet attached to the email at Appendix 000329, which outlines additional words that Backpage stripped from these ads, including little girl, teen, even Amber Alert. These are the words Backpage scrubbed from the ads on its website. Ms. McDougal, Backpage has argued to the subcommittee and again in federal court the documents we subpoenaed were all protected by the First Amendment to our Constitution. I went to law school, so did Senator McCaskill, and we don't remember learning that instructions to cover up a crime are protected speech. But you argued that they did. Ms. McDougal, I'd like you to look at the two documents I just mentioned, the documents about stripping words like rape, little girl from ads before publication, and tell me whether it is still your opinion that they are protected by the First Amendment.
After consultation with counsel, I decline to answer your question based on the rights provided by the Fifth and the First Amendments, and to the extent any particular question might require the disclosure of protected attorney-client communications or attorney work product, I also decline relying on the common law privileges.
Ms. McDougal, do you believe that Backpage is entitled to immunity under Section 230 of the Communications Decency Act for ads which it deletes these kinds of words?
After consultation with counsel, I decline to answer your question based on the rights provided by the Fifth and First Amendments, and to the extent any particular question might require the disclosure of protected attorney-client communications or attorney word product, I also decline relying on the common law privileges.
Okay. Ms. McDougal, in a sense, we're here today because of your testimony. On June 19th, 2015, when you sat down for an extended interview with our lawyers, you said under questioning that Backpage sometimes edits out offending words and images from advertisements. As far as I know, this subcommittee is the first to report that information. You never disclosed that to law enforcement, as I understand it, and you certainly did not disclose that to the victim plaintiffs in the many lawsuits against Backpage. As General Counsel since April 2012, you've been responsible for the company's litigation. Recently, the First Circuit Court of Appeals, in an opinion joined by retired Supreme Court Justice David Souter, said that, quote, a persuasive case, end quote, had been, quote, made that Backpage has tailored its website to make sex trafficking easier, end quote. But then the court affirmed the dismissal of the lawsuit under the Communications Decency Act for the familiar reason that Backpage is just publishing third-party content and that Congress had made it immune for that. My question is this. When Backpage filed its briefs in the First Circuit case under your supervision, were you aware of Backpage's practice of altering the content of adult advertisements by removing evidence of criminality?
After consultation with counsel, I decline to answer your question based on the rights provided by the Fifth and First Amendments, and to the extent the particular question might require the disclosure of protected attorney-client communications or attorney work product, I also decline relying on the common law privileges.
Ms. McDougal, can you tell us if your outside litigation counsel in that case was aware of your editing practices when they signed and submitted the briefs in that case, convincing the court to throw out the lawsuit on the theory that Backpage just posts whatever it receives, other people's content?
After consultation with counsel, I decline to answer your question based on the rights provided by the Fifth and First Amendments, and to the extent any particular question might require the disclosure of protected attorney-client communications or work product, I also decline relying on the common law privileges.
Okay. Well, let me ask you one more question. I'd like to ask you about Backpage's cooperation with law enforcement. You all talk a lot about that. Here's what you said, and I quote, "Commendation for Backpage.com's responsiveness and thoroughness with law enforcement investigations and stings are replete in our records. Backpage.com responds to law enforcement requests within 24 hours or less in most cases." I think one thing is very clear and comes out of the report, and that is that what would assist law enforcement in their investigations is to have the original unedited advertisements for the sale of a trafficked child or an adult prostitute, as opposed to the altered version that appears on your website. So providing law enforcement the actual ad that you received. Ms. McDouga, when responding to law enforcement requests or grand jury subpoenas, did you ever tell law enforcement that ads reported to them may have been sanitized?
After consultation with counsel, I decline to answer your question based on the rights provided by the Fifth and First Amendments, and to the extent any particular question might require the disclosure of protected attorney-client communications or attorney work product, I also decline relying on the common law privileges.
Ms. McDougal, is it your intention to invoke your Fifth Amendment privilege with respect to questions on any topic?
Yes, it is.
Okay. Again, the subcommittee respects your assertion of the Fifth Amendment rights, and on that basis, we will excuse you along with the rest of the panel.